The next topic is forest conservation rules. Very important topic, very important from the environment section, and it is important because three things I would stress upon the fact that for environment, Wildlife Protection Act 1972, Forest Conservation Act 1980, Indian Forest Act 1927, National Forest Policy 1988, Forest Rights Act 2006. One should always be prepared. This year there was a question from 1972, WPA 1972, this very year. Okay, and that thing I already taught in one of my current affairs lecture. Okay, so UPSC is not asking out of the box questions. You just need to observe the pattern. Okay, there are a lot of things which will definitely be asked in UPSC. Like the acts that I pronounced recently was, first one is IFA, Indian Forest Act 1927. Then WPA 1972. Then the Forest Conservation Act 1980. Then National Forest Policy 1988. And then Forest Right Act 2006. You should have your notes prepared on these things. You cannot skip them. Okay. Now, why this is in news? There are two news sections that I have taken. Congress says, first of all, look at this one, 10th July and 11th July. Okay. 10th July, Environment Minister said that new forest conservation rules do not dilute the Forest Rights Act. Congress says that new forest rules dilute the tribal rights. Center says aimed at streamlining the process of streamlining the process of identification and granting lands for industrial purposes. Whereas the opposition says that these rules will now be used to dilute or take away the rights of tribals or traditional forest dwellers. That means the main opposition of the opposition party is that the new regulations that that have been drafted in the Forest Conservation Act 1980 will dilute the provisions of FRA 2006. On FRA 2006, I have made a detailed lecture. Okay, go through that lecture. Okay, the topics that I bring in here are very important. You should understand, because these topics are continuously in news. Economic, special economic zone, like what is a national park, what is all these things, they are very important. They are continuously in news. Okay. So let's see at what is how the governance of forest takes place in India. Laws relating to forest governance. So the very first law that came for forest governance came in 1865, the Forest Act of India. Okay. It was made by British for their own benefit. Then it was, after 15 years, a new law came, and then a very comprehensive law came in 1927, Indian Forest Act. Okay. Still that act is working. Forests were under the state list. After the independence of India, forests were under state list until 1976. When the 42nd Constitutional Amendment Act, what it did, it transferred it from state list to concurrent list. Okay. That means both state government and central government have powers to make laws against what? Again, for the conservation protection of forests. That means, very important point to note here is, if a law made on concurrent list, okay, this also brings us to polity. See, it's interdisciplinary in nature. The point is, any law made on concurrent list by state government can be overridden by central government. Okay. The law made by state government on a concurrent list can be overridden by a law made by parliament. There is one popular catch there, that is, if a law has been made by state government and it has been reserved for president's consideration and the president has given assent to it, then the central government law cannot override it. Okay. Understood? Fine. Now forests are under concurrent list. Every state government has the right to determine the definition of forest. Very important point here, that every state government has right to determine what constitutes a forest. Actually, there was a case in Supreme Court on the definition of forest itself. Okay. Supreme Court said that the definition of forest should be taken from the dictionary definition. Okay. Moreover, there was also a meeting of MOEFCC, Ministry of Environment, Forest and Climate Change, on the definition of forest, where MOEFCC said that, the ministry said, central government ministry said that states, since the type of forests are very diverse in India, okay, the states are better equipped to come up with a definition for themselves. That is why Ministry of Environment, Forest and Climate Change has not issued a definition of forest. Okay, hence the state governments are free to determine what a forest is. Okay, the state governments have forest departments which work on the provisions of Forest Act, Indian Forest Act 1927, and implementing the National Forest Policy 1988. Okay, now in 1976 में क्या हुआ? Forest was brought under concurrent list. Okay, फिर 1980 में क्या हुआ? Forest Conservation Act 1980 came. ठीक है, 1980. फिर 85 में what happened was, central government formed a ministry for conservation of forest, that is called MOEFCC, Ministry of Environment, Forest and Climate Change. Now climate change was added recently. It was original Ministry of Forest and Ministry of Environment. Okay, the Forest Conservation Act 1980. Okay, now in 1976 what happened, this concurrent list से इसको डाल दिया, state list से it was brought to concurrent list. Now it was brought to concurrent list. Now central government wanted some power game to play some power game here. What they did, they made a law, Forest Conservation Act 1980. This law brought them into the picture. Okay, this law brought central government into the picture, and it gives the right to central government to frame policies and laws for the conservation of forest. It all now the central government has empowered themselves through a law, parliamentary law, to make policies and laws for the conservation and preservation of forests. Okay, now the actual bringing to concurrent list has happened. And then Forest Right Act 2006 came. It was one of the most revolutionary act that has been brought. Although it was diluted a lot, but still it gave a lot of rights to tribals. Okay, Forest Right Act 2006. Tribal means traditional forest dwellers, a right of habitation and conservation of forest. So these are the laws that you have to prepare for UPSC. You have to look into these laws and you have to be prepared for it. In addition to Wildlife Protection Act 1972. Now what are original forest conservation rules? See, there is an act, Forest Conservation Act 1980. The government is empowered to issue rules under that act. So these original conservation rules were there. These rules have been now amended through a new notification, and that new notification is being challenged. To understand the new notification, we need to understand the original conservation rules. What were the rules? For forest land beyond 5 hectares, if a forest land is diverted and the area of that land is less than 5 hectares, the central government need not be consulted. Okay, the state government has all the power to grant rights for the diversion of that forest land if the area is less than 5 hectares. But if the area is greater than 5 hectares, the central government approval is very much important. In that case, the process of approval is through Forest Advisory Committee, which is under the Ministry of Environment, Forest and Climate Change. Okay, what happens is, state government sends the proposal to FAC, Forest Advisory Committee. Now FAC analyzes if there is a plan, okay, if the land is being diverted, so the company which is diverting that land for industrial purpose or some other purposes, that company has put a plan in place to ensure that ensuring damages occurring from felling of the trees in that area and denuding the local landscape will be minimal, first of all. Okay, and also there is one CAMPA fund, compensatory afforestation fund. Okay, that is called CAMPA fund. Now that company is also contributing to that fund that is also insured. The said piece of land does not cause damage to the wildlife habitat. Okay, that means the traditional wildlife habitat is not affected. Like the said piece of land does not lie in the core zone of a tiger reserve. Okay, ऐसा नहीं है. That is being ensured by Forest Advisory Committee. The state government also has to ensure, okay, before sending this FAC proposal to the this proposal of land diversion to Forest Advisory Committee, the state government has to ensure that the provisions of FRA 2006 are complied with. Now, what are the provisions that we are talking about? The provisions that we are talking about from FRA are that any land that is being diverted, okay, and if the people were living there, the traditional forest dwellers were living there, then their rights have been settled. Then their rights are being settled. Their rights mean the traditional forest dwellers have the right to live in forest, okay, and right to carry out their livelihood in the forest in the traditional method, right? Of course, they can use minor forest produce as well. That means if a group of people were living in some area, so their consent has been taken before the diversion of that land, and that is mandated by FRA 2006. That is mandated by FRA 2006. Okay, FRA 2006 mandates that whenever the diversion of a forest land is happening, the Gram Sabha in that specific area, the written consent, okay, and informed consent is taken from the Gram Sabha where the diversion of land is happening. Okay, this is a very crucial provision of FRA 2006 that provides the people who are traditional forest dwellers with the right to their own land. Okay, and also there's a compensation if the diversion of land is such that people have been uprooted from that, so there is a compensation of rupees 10 to 15 lakh per hectare. So this is all the state government has to do before they send the proposal to Forest Advisory Committee. Okay. Now, what are the new rules? What are the changes that we are talking about? The Forest Conservation Rule 2022 delinks the mandatory FRA compliance for seeking forest clearance under infrastructure projects. That means now the state governments do not have to perform a FRA compliance audit prior to sending the proposal to FCA. FCA means FAC, Forest Advisory Committee. Now, what is the problem with this? The problem is that the state government, earlier what happened was the state government made sure that their claims of tribal people were settled. Okay? And then only the central government interfered. And once central government passed it, so the state government was free to divert that land. Now what happens is, an industrialist comes and he says, I want this land. He pays to the state government for that. State government does not perform any FRA audit and they directly send the proposal to FCA. Now FCA clears it and sends it back to the state government. Now the ball lies completely with the state government. The state government will be very happy to implement the diversion of the land and not even complete the FRA audit. But prior to this, it was compulsory to complete a prior audit before sending it. Okay, otherwise FCA will not be considering your plea. Now that rule has been changed. The rules make a provision for private parties to cultivate plantations and sell them as land to companies who need to meet compensatory forestation targets. Okay, this is also this is also going to cause harm to the forest, because it has made a provision that any private property or private entity like people can have their lands of cultivate, basically make provision for private parties to cultivate plantations and sell them as land, because the companies which are diverting the forest land, they have to also do compensatory afforestation. Okay? Compensatory afforestation means if I have diverted 5 hectares of land here, I will have to plant 5 hectares of forest somewhere else. So now government says that within the plantations itself, plantations can also be offered to the companies for their completing their forestation targets. It has a disadvantage that earlier what the companies did was they did plantation in some places where it was actually needed, right? Now plantations are already in some such areas jahan pe biodiversity rich hai and that can naturally grow. So that is going to cause harm. Government has allowed the forest right to be settled after the approval of FAC, right? That can have damaging consequences as we discussed in the very beginning. Okay, now look at what's the reality is. What's the reality of Forest Advisory Committee is. In 2000, an analysis by Legal Initiative for Forest and Environment found that FSC generally approves land for diversion without examining the questions around consent. Consent means the written and informed consent of the Gram Sabha for the diversion of the land from forest to other uses. So it said that FSC generally approves it without even going into the nature of the consent. Nature of the consent means has the consent been taken voluntarily or not, and were the people properly informed about the effects of the diversion of land or not. Okay. In the first 6 months of 2019, of the 240 proposals, 193 were recommended. Majority of the proposals were accepted, 40 were deferred and 7 rejected. Recommended 193 proposals meant 9,220.64 hectare of land diversion for road, dam, irrigation infrastructure and hydropower. That means FCA most of the time does not go into questioning the nature of the consent, and it might not be properly analyzing or assessing the impact of diversion of forest lands. Okay. So I hope you understood that. If you have any questions on this, kindly ask me. I'm here to help.